Good afternoon, everyone. Thank you for joining into this webinar this afternoon. My name is Andrew Fawcett. I'm a senior counsel with Aotearoa and its Technology, Media and Telecommunications team. Our team is responsible for dealing with data protection laws, not just in the UAE, but regionally as well. And for the purposes of this presentation, I'm joined by my colleague Krishna Jhala, a senior associate who works with me. We are actually based in Abu Dhabi, where in the ADGM, where this new law is taking effect. So with that, we'll get started into the substantive presentation. First slide, please. So the Abu Dhabi Global Market has issued the new data protection regulations 2021, which were enacted on 11 February and published on Valentine's Day. Now, the new regulations, it's not a standing start in terms of data protection in the ADGM. They replaced the existing data protection regulations from 2015. Now, there's a transition period between the old and the new, with 6 months for any new establishments that are formed after 14 February, and then 12 months for existing establishments in the ADGM going through to 14 February next year. Now, just a more broader thing is that the reason for data protection laws, you potentially have heard the saying that data is the new oil. That's not necessarily true, but I think is linked to the fact that the companies of leading capitalization in the world currently tend to have their business based on data. Your Facebooks, your Alphabets, your Amazons. Most of the top 10 companies have some databases. Now, given that privacy is kind of an individual's right, it really rests with governmental organizations to balance those rights. Individuals, we don't really have the power to do it for ourselves. It's for our governments to do that balance. So back in 2018, the EU essentially refreshed data protection laws by issuing their General Data Protection Directive. Now, there had been previous data protection laws, but most of them, and particularly the EU's prior directive, came in 1994. Which was really just at the time that the internet was starting. And so as with most laws, laws tend to be reactive rather than proactive. They have to do a thing of catching up. None of the laws from the early 90s really anticipated the digital world that we live in now. And generally laws need to have a generational catch up in any case. So the GDPR came in force in 2018, essentially setting a benchmark. Next slide, please. So what the ADGM regulations do. Now, the previous 2015 regulations were based on the former EU Data Protection Directive. And so the new regulations essentially are linked, benchmarked against the GDPR. Now, there's a lot of sensible reasons for that in terms of if that is the sort of become the global standard. And the ADGM, as its name is it's a global market. So operating as a global market and dealing with things to international standards, adopting the best practice standard and taking a consistent approach makes a lot of sense. Now, you know, as a lawyer, a lot of times when you do things like these webinars and you're going through things, it's almost like you're critiquing a law. It's a lot harder to write a law than to interpret it. And I think that sorry, I understand some people having some sound problems. The thing with this law is that what the ADGM has done, also following on what the DIFC had done last year, is to present a regulation and a law that I think is a really good example of how a jurisdiction outside of the EU puts into place GDPR-like standards. And it's a good representation. And again, the other thing with these laws is, yes, if you're a business operating, there's an issue about extra compliance, but essentially these laws are best practice standards. And if you're dealing with a lot of data and things like that, essentially in this modern world, they set the standards for what you need to be dealing with. Next slide, please. So I'll skip over this part fairly quickly. There's a few change in definitions to do with the updating of the law. Now, the critical thing is understanding what these laws deal with, and it's around personal data. Now, that's information about a natural person who can be identified or identifiable. So it has to be about someone in particular. It's not about businesses. There's broader description of what they call special categories of personal data, and we'll get into that in more detail. Next slide, please. So just continuing on, there seem to be some people having some problems with sound, but I think we are going clear on that. Now, just taking you through these new definitions, again, these are just concepts that are important to stuff we're going to be discussing later on. The other thing just to note is that we will make the slides available through a link at the end of the session. Next slide, please. Okay, so these are quite important definitions. The law applies to an establishment, and basically that's an entity that's established, registered, or licensed to operate within the ADGM. Or there are also some organisations that are in the ADGM that aren't licensed, but or for some reason they've registered and or not registered or licensed, for that had an exemption to them. There's a definition of child. I mentioned this in that, so generally being a financial free zone, the civil laws of the UAE do not apply in the ADGM. Under the onshore consumer transactions law, the legal age of majority for a child is is 21. So there's just a slight thing between here in the ADGM and onshore UAE. 18 years old is common in data protection laws, but there's just that, just mentioning that slightly. There's pseudonymization, easy word to say. The only thing is with this is you need to have a distinction between anonymization. Now, as I said before, personal data is about an identifiable individual or someone who can be identified. The concept of true anonymization means that you remove all that ability to identify somebody, and then the data would cease to have the characteristic of being personal data. But it's been recognized by many regulators that true anonymization is quite hard to achieve. Pseudonymization is basically a step down in that most of the information is removed, but it is still possible to re-identify. Next slide. The law also is updated in terms of bringing in sort of more recent concepts with the way that data is processed at the moment, and there's expanding the concepts of health data and into biometric data and genetic data. As everyone knows at the bottom, the dactyloscopic data is a data relating to the study of fingerprints to establish identity. So it's just giving the concept that the law is recognizing that a lot of other data is being collected in this day and age. Next slide, please. Okay, so critical threshold point. So who does this particular law apply to? So it's an ADGM law, and it's not a national UAE data protection law. It applies to the processing of personal data in the context of activities of an establishment being an entity in the ADGM and registered or exempt, and a controller or a processor where the law extended just beyond controllers to also include processors, being people who processing data on behalf of somebody else. And it applies whether or not the processing actually takes place in the ADGM or not. And another interesting point is that point 2 here is that if you're a processor processing data on behalf of a controller who's actually outside of the ADGM, the processor still must comply with the requirements of the regulations as far as possible. And then finally, the regulations apply to natural persons, whatever their nationality or place of residence. Now, this is something that makes sense, but it's where the ADGM regulations differ from the GDPR. Now, you may have, if you're working in the space, that GDPR has this concept of extraterritorial effect, and that the focus of the GDPR was the rights of data subjects in the EU, wherever the processing takes place. The ADGM, and indicated in its consultation, because of the jurisdiction and the scope of the ADGM, it's appropriate that the focus is on where the controllers and processors are located, and it's the need to adhere to the law, and also recognises that those controllers and processors may actually be dealing with people's data who are outside of the ADGM. So that's just a slight distinction there. Next slide, please. Okay, so critical part in any data protection law is basically the principles for the processing of data. So essentially here we're sort of comparing what was under the old regs and the expanded regulations, but essentially personal data has got to be processed lawfully, fairly, and in a transparent manner to the data subject, be collected for a specified, explicit and legitimate purpose, and not processed in a manner that's deemed incompatible with that. It needs to be accurate and kept up to date, kept in a form that permits identification of data subjects for no longer than is necessary, and processed in a manner with appropriate security. Next slide, please. Now, the critical thing for data protection law is that basically it says that it's only lawful to process personal data only and to the extent that one of these 6 conditions apply. And that's standard. But the new regulations expand on the old regulations. One of the first things is whether the data subject has given consent to the processing for one or more specific purposes, whether the processing is necessary for performance of a contract, or whether it's part of some pre-contractual steps. It's whether it's necessary for compliance of an applicable law to which the controller is subject to protect the vital interest of the data subject. Now, look, the vital interest of a data subject generally only apply to matters of life and death, and where the data subject is incapable of giving consent. So it's sort of more the medical emergency, not the need to get a PS5 at the Galleria Mall in a hurry. Now, it's whether it's also necessary to be carried out by a public authority, and the exercise of an ADGM body, so the Commissioner, the Financial Services Regulatory Authority, or the courts functions. And finally, whether it's the processing is necessary for the purposes of legitimate interest pursued by the controller or a third party, but that has to be balanced against the interest and rights of the data subject. Now, the final one, this legitimate interest, is the most flexible of the lawful basis, but it's essentially you need to understand it as being where there's a clear benefit to you or another, and there's going to be a limited privacy impact on the individual, and that the individual could reasonably expect that you're going to use the data in a way, and you're unlikely to object to it. It shouldn't be the default basis because it doesn't apply to everything. And also you need to understand you've got to justify processing under this basis and have an assessment of the impact. I mean, you don't, if it's for performance of a contract, then you know you fit within that in a lot of ways. Now, while a lot of things are taken with the data protection laws as being, you know, an enhanced need to compliance, things like that, this whole lawful basis for processing, as a lawyer, I really like, because honestly, it makes it clearer as to what the legal basis are for dealing with data, because essentially as it stands in terms of the onshore laws, unless it's in a particular case, you're looking at consent or some other lawful permission. That this lawful basis of processing, it sets out you know, how you can actually deal with data and gives you the basis for doing it. So in terms of the data protection laws getting a bit of a hard knock, this is a really important thing, and it actually is really important for people dealing with data, in that it gives this basis for processing. Next slide, please. I said before that data has to be collected for specific purposes and not to be further processed in a manner that's incompatible with those that process. Now, the new regulations give some guidance how to work out whether a new purpose is compatible or not, and we've set them out there. So there's got to be a link. You need to look at the context, the nature of the data, and the possible consequences, and whether you're using appropriate safeguards. Look, as a general rule, if the new purpose is different from the original purpose and would be unexpected or would have an unjustified impact on an individual, it's likely to be incompatible. An example would be a GP discloses to her husband her patient list, and husband runs a hotel and uses that list to offer staycations to patients who are needing recuperation. That wouldn't be compatible. Next slide, please. There's one thing with the regulations is clarifying the use of data for research or archiving purposes. Now, the most important thing here is probably the paragraph at the bottom. As I said before, the lawfulness of processing has to come into one of those 6 categories: consent, etc. Researching and archiving is not itself a lawful basis. However, processing for research and archiving purposes is basically deemed compatible with the initial purpose, subject to these safeguards in place, that there's technical and organizational measures that the processing doesn't cause substantial damage or distress, and that it's basically for the not being carried out for a particular data subject. So once you've collected data on a lawful basis, research and archiving is permitted. Next slide, please. One of the things with the law is that basically once you cease processing, there's a requirement to either securely and permanently erase that data, or anonymize, pseudonymize, or encrypt the data. Under the new regulations, it recognizes that if a controller is unable to ensure this, then they can also archive the data in a manner which is defined in the law as being put beyond further use. And basically that means that the data can't be used to inform any further decision regarding the data subject or in a manner that affects them. And then there's also exemptions from the erasure and anonymization is where it's set out for legal claims and defence, necessity of compliance with applicable laws, the scientific research and the public interest. The only thing is that I'll just observe is now this provision similar to a provision that's in the DIFC law, but it's not something that's the GDPR itself. If anything, you know, under the GDPR and the pseudonymization or encryption of data for after processing for terms longer than is necessary generally isn't sufficient. However, there was some guidance from the Information Commissioner in the UK recognising that this was one of the areas that entities struggled with in terms of what to do with the data when they've finished using it. So essentially, this is a measure that will help controllers in the the ADGM and DRC where they have this provision. Next slide, please. So a critical thing that's been upgraded in the new regulations is what actually consent is. Now, it's said in the law, there's specific areas where you're allowed to do things where you've obtained the data subject's consent, and that's just one of the bases. But where you're relying on consent, the law imposes clarity around what that actually means, and essentially it has to be given freely and informed. It's got to be something of a clear and affirmative action, and being basically an obvious, unambiguous indication of consent. The law actually states that silence or having a pre-ticked box or an activity isn't consent. It also further states out that if you're doing processing and it's multiple purposes, then or for multiple things, the consent that you're relying on has to be clearly distinguishable for each purpose and use clear and plain language. It also is that if you've got the data subject's consent, they have to have the ability to withdraw that consent any time, and it has to be able to be easy to do that and without undue effort. If you have had consent and it gets withdrawn, it doesn't affect what you've done with during the time that you have had consent. Next slide, please. Now, it's for the controller to demonstrate that they've obtained consent. But one of the things in assessing whether consent is freely given is whether the data subject has a genuine free choice and is unable to refuse or withdraw consent. Now, a lot of the guidance in the EU countries is that it basically says that sort of public authorities or and particularly employers or organisations in a position of power over an individual generally should avoid relying on consent, because there's an argument that there lacks this free choice, but they can rely if they're confident they can demonstrate that it's freely given. So you know, that doesn't mean that employers can't rely on it in every circumstance, but you just need to take care as to the circumstances. You know, if I'm wanting to send a courier through work and have the cost deducted from my pay, and I consent to that, clearly that I'm doing that with my free consent. But in other situations where there's an imbalance of power, it mightn't be that case. So take care with that if you're an employer. Next slide, please. One of the significant changes in the compliance regime for with the regulations, and it's also something that came in with the DRC regulations that has been something that people have been struggling with, is that there's now a particular requirement to keep a record of your processing activities. and the law sets out what those activities are, and each controller and processor has to keep a written record of its activities, and that record has to be available to the Commissioner on request. Next slide, please. Okay, so the areas of special categories of data, this is what was generally sensitive personal data. It's the special categories of data is that where further protection is needed is because the data is particularly sensitive. We set out the definition earlier. It's the kind of things that sort of ethnic origin, health, political beliefs, and things like that. It's always quite interesting to me that it doesn't include financial information. Now, again, the data can only be processed if one of the specific legal basis for processing that is set out under the law can be utilized, and you need to work through those. But one of those does relate to the if there's a substantial public interest. And if we could just go to the next slide. So it's permitted to process on the ground of special categories if it's necessary for reasons of a substantial public interest. Now that the new regulations basically clarify this and set out what a specific public substantial public interest includes. It's set those out in detail there. Just noting that where the UK Data Protection Act does similar, they have some sort of 23 grounds. Next slide. Now, for both the processing for the substantial public interest, and also one of the other grounds is for processing sensitive personal special categories of information, is where it's necessary for exercising rights in the field of employment law. And both of these, it's permitted if there's an appropriate policy document in place in accordance with the law. So basically, most employers are going to have to deal with this because you will be collecting sensitive information and stuff regarding insurance, things like that. And so the law describes what an appropriate policy document is, and set that out there. Basically a document that explains how it's processed, the controller's policies and that. My initial thing was that this is similar to a privacy notice, and it is similar, but it's not exactly the same thing. Again, the Information Commissioner in the UK has a specific template for what an appropriate policy document is, and until we get some more guidance, that might be a useful template to be looking at. Next slide. Just quickly, based on this point, basically, if the purpose for which the controller processes data no longer requires identification, the controller is not obliged to collect data or maintain data to identify the data subject. However, they can't refuse to take that additional information from a data subject who's exercising their right to, which Krishna will discuss, to access their information. Bit of a technical point. Moving on, next slide, please. Now, the laws introduce this concept of data protection by design or default. So basically, the the requirement is that you integrate data protection considerations into business practices from the design stage and through the life cycle. And it's to encourage organizations to consider data protection up front and have default settings that are privacy friendly. So if you're building a new IT system for storing and accessing personal data, you're required to review the privacy and data protection compliance and perceived risks at the start of the project, not when it's gone live, and not after adding considerations afterward. So if you've got a disruptive ride-sharing app or something like that that looks great, you need to be building in your data protection at the outset. That leads into the next slide. This isn't new under the law, but it goes further again. So and this is more of for the compliance, the more organizational side of things, is that basically a key principle is that you've got to exercise, implement appropriate technical and organizational measures to protect data against security breaches and things like that. So that's critical. There's a reference to state of the art, but that's in newly defined terms. So basically, your need to comply, next slide please, is based on what the situation is at the time. Now I've run a bit from time. I'll now hand over to Krishna for her matters.
Hi everyone. I'll take you through the remainder of our presentation and discuss with you the additional new concepts that have been introduced under the ADGM Data Protection Regulation 2021. If you could just move forward through the slides, because I think this was discussed, and then the next one as well, and the next one as well. Right, so I'll begin with data protection fee. So the 2021 regulation states that the controller must, before or as soon as reasonably practicable after it starts processing personal data, pay a data protection fee to the commissioner. This is an annual fee. So while the concept of data protection fee is entirely new under the 2021 regulation, essentially it is the same fees that the controller was paying under the 2015 regulation at the time of filing the notification with the registrar. So if you would remember, the fees at the time of filing the notification with the registrar under the 2015 regulation was 300 USD, and then there was a renewal fee of 100 USD. So like I mentioned, so in the 2021 regulation, this has been specified as a separate provision under the data protection fee provision. However, it is essentially the same fees that was actually being paid. What the fees are under the new regulation is yet to be specified by the board. I would like to mention here that this data protection fees is exempt for establishments that are that have employees less than 5. So for entities that are employing less than 5 employees, they do not need to pay this data protection fees. Apart from the data protection fees, the new concept that has been introduced by the board is the separate independent supervisory authorities of the data protection, which is headed by the Commissioner of Data Protection. And at present, Mr. Sami Mohammed has been appointed as the commissioner by the board. We'll move on to the next slide. Similar to the concepts under the GDPR and the DIFC, the ADGM 2021 regulation has also introduced the high-risk processing activities. As the name suggests, it involves processing activities which result in a high risk to data subject rights, or where a bulk of personal data is being processed, or where data processing involves special categories of data, or where data processing involves adoption of new emerging technologies. High-risk processing activities may also involve processing where a systematic and extensive evaluation of personal aspects relating to a natural person is involved. Prior to conducting high-risk processing activities, the controller must carry out an assessment of the impact of the envisaged processing operations on the protection of personal data. So this is the new element that was not existing under the 2015 law, but has been borrowed from the GDPR and the DIFC and is included in the 2021 regulation. We'll move on to the next slide. Another important concept, again borrowed from the GDPR and existing under the DIFC, is appointment of a DPO. So the 2021 ADGM regulation provides 3 specific instances where a DPO must be appointed. That is, where processing is carried out by a public authority, except for courts acting in their judicial capacity, or the core activities of the controller or the processor consist of processing operations which, by virtue of their nature, scope, and purposes, require regular and systemic monitoring of data subjects on a large scale, or the core activities of the controller or processor consist of processing of large scale special categories of personal data. So apart from these 3 instances, it is not required to appoint a data protection officer, but there is an exception to this condition. We'll cover that in the next slide. So the law provides the requirements of appointing a DPO, which is a DPO may be appointed in respect of a single entity, a group, or a multiple independent entities. The DPO can either be an employee of a controller or processor, or it can be an individual. They have entered into a documented contract by virtue of being a third party. The DPO does not need to be a resident within the ADGM. The contact details of the DPO must be published on the controller or the processor's website and should be readily accessible. In case of change of the DPO in terms of appointment of a new DPO or resignation of an existing DPO, the commissioner needs to be notified within 1 month of that change. And the exception that I was talking about is that while I mentioned in the previous slide the 3 instances where the DPO needs to be appointed, the other exception to that is in case where an establishment, although employing less than 5 employees, but is carrying out high risk processing activities, then even that establishment needs to appoint a DPO. Again, like I mentioned, all these provisions concerning the DPO were not present in the 2015 regulations and have been included in the new regulations. In terms of what a DPO needs to know, so the DPO should have knowledge of the new regulation. The DPO should act independently and on his own authority. The DPO should have direct access to the highest level of management. It should have timely and unrestricted access to information with the controller. And the DPO should have the ability to cooperate transparently with the commissioner, subject to privileges and confidentiality requirements. We'll move on to the next slide. The new data protection regulation imposes additional legal obligations on the processors as well as the controllers. So much like the DIFC 2020 law, the 2021 ADGM laws also prescribes certain obligations for the processors, which involve that where a controller is engaging processors, they must have a legally written binding agreement for governing any processing between the 2 entities. The processor must provide sufficient assurances for implementing appropriate technical and organizational measures. And where the processor intends to engage sub-processors, it can only do so with specific written authorization of the controller and on a legally binding written agreement being present. We'll move on to the next slide. Joint controllers is another new concept which is introduced under the 2021 ADGM regulation, which says that where there are two or more controllers who jointly determine the purpose and means of processing personal data, they shall be called as joint controllers. And it is a requirement even for the joint controllers to have a legally binding written agreement between them two, which clearly identifies each of their responsibilities and obligations towards the law. Moving on to the next slide. Okay. In terms of transfers outside the ADGM, I would say that the new law continues to divide the transfers under two subheads, which was similar to the 2015 law. That is, the two broad categories being transfers with adequate level of protection and transfers lacking adequate level of protection. So in terms of transfers having an adequate level of protection, the 2021 regulation recognizes the list of jurisdictions that was determined as having adequate level of protection under the 2015 regulation. That is, so far, the list holds good until it is further revised or scrapped by the commissioner. In terms of the commissioner determining if any receiving jurisdiction meets the adequacy requirements, the commissioner will take into account several factors, and these include the rule of law, general respect for individual rights and the ability for individuals to enforce their rights, the existence and effective functioning of independent supervisory authorities in those receiving jurisdictions, and the international commitments and conventions, again, prevailing in those receiving jurisdictions. The deviation from the 2015 law has been with respect to the specific authorization that was available to controllers when transferring when transferring personal data to jurisdictions not having an adequate level of jurisdiction. So this requirement of seeking an authorization has been scrapped, much like the DIFC, where even the DIFC law has scrapped this specific authorization that could have been obtained previously under the old laws. We'll move on to the next slide, and I'll continue to discuss the transfers lacking an adequate level of protection. So, like I mentioned, so the list of jurisdictions that have been provided an adequate level of protection continues to hold good. Apart from that, the controllers or processors would need to have appropriate safeguards in order to transfer data to jurisdictions not having adequate levels of protection. So in terms of what is considered appropriate safeguards would include a legally binding instrument between the public authorities, the use of standard data protection clauses as adopted by the commissioner. And do note here that the law in its current form states that the commissioner may approve the then current standard contractual clauses imposed by the European Commission as well. It could also, in the appropriate safeguards could involve an approved code of conduct, an approved certification mechanism, and binding corporate rules for transfer of personal data between members of a corporate group. So apart from these 5 appropriate safeguards that are actually similar or same, I would say same to the DIFC one, the 2 additional appropriate safeguards that have been provided by the ADGM regulation are they say that contractual clauses as approved by the commissioner between the controller and processor or between controller, processor, and recipients of personal data may also be regarded as an appropriate safeguard. And additionally, provisions can also be inserted in the administrative arrangements, such as the memorandum of understanding between the public authorities or domestic or international bodies. In terms of transfer to jurisdictions outside the ADGM, in absence of an adequate level of protection or appropriate safeguards, the transfer can take place on the following derogations. And these derogations, as I've set out in the slide before you, will include data subjects' explicit consent, or where the transfer is necessary for performance of the contract or conclusion of the contract, or where the transfer is necessary for reasons of public interest as recognized by the applicable law, or to meet the requirements of law enforcement agencies of the UAE, and or to protect the data subject's vital interests, or necessary for establishment, exercise, or defense of legal claims. So I would say this section, in terms of introducing the appropriate safeguards as well as derogations, is in itself a new provision, is a deviation from the 2015 law, because the appropriate safeguards were not provided previously. And likewise, while there were a few derogations in the 2021 laws, these have been expanded. We'll move on to the next slide. This is again a new concept, the data sharing, which is presently existing under the DIFC 2020 law, which states that the controller or the processor may receive a request from public authorities to share personal data that they are processing. And when that happens, the controller or processor must be mindful of their obligations and should be compliant with their obligations under the new regulation. The controller processor should exercise reasonable diligence to determine the validity and proportionality of the request. They may assess the impact of data subjects' rights for meeting this request, and where appropriate, they may seek assurances from the requesting authorities before sharing such information. Like I mentioned, this was not covered under the 2015 regulation and is a new concept borrowed again from the DIFC. We will move on to the next slide. Okay, this slide talks about information notice to data subjects, which I would say existed under the 2015 regulation and also exists and is also equivalent to the transparency requirements under the GDPR. So now under the 2021 regulation, the law states that where the controller directly obtains information from the data subjects, it should provide those data subjects in a concise, transparent, clear, accessible manner. The information, and such information would involve like the names of the controller, the names of the DPO, the lawful basis for processing, or the recipients or categories of personal data, or if at all the processing will involve transfer to a jurisdiction outside ADGM or not. So these are the additional information that has been included from the 2015 law. And in terms of where the information is not being obtained directly from the data subjects, the new regulation stipulates a time boundness to this, which states that the data controller should provide this information to the data subjects within first 2 months of obtaining this information, or no later than first communication with the data subjects, or no later than when the personal data is being first disclosed to the processor or third party. So basically this aspect of making providing information notice to data subjects time bound is the new element under the 2021 regulation. We will move on to the next slide. As you can see, the rights set out in the slide in front of you were the rights that were forming part of the 2015 regulations. That is, the 2015 regulation granted the data subjects the right to access, right to rectify, erase or block personal data, and to object to personal data, including at the time of direct marketing purposes. What has changed under the 2021 law is that, again, the right to access has become time bound. That is, it is the duty of the data controller to respond to any data subject access request within a period of 2 months. And this period can further be extended by 1 month. One should note that this time period is different from that which is provided under the DIFC, because under the DIFC, the time period for responding to data subject request is initially 1 month, and which can further be extended to another period of 1 month. So in actuality, the data subject access rights provided under the ADGM gives greater period for the data controllers to respond. We'll move on to the next slide. The 2021 regulations provide new and enhanced data subject rights, and these include the GDPR style rights. For example, the right to withdraw consent, which Andrew discussed in his slide on consent. That is where consent is the only mechanism for processing personal data. In that instance, if the data subject wishes to withdraw his consent, then the data cannot be processed any further. Then the right to restrict processing. This may happen where the data subject may contest the accuracy of a personal data, or where the controller is no longer required to process data for the purposes it was initially collected. So in these instances, the data subjects can exercise their right to restrict processing. Apart from these two rights, there is the right to data portability, which means the right to receive certain information from the controller that the data subjects has shared with the controller. And lastly is the right not to be subject to decisions made solely on automated processing, including profiling. I would mention here that the DIFC 2020 law provides an additional right, which is the right to non-discrimination, but that right is neither covered in the GDPR and nor does the 2021 ADGM regulation cover that right. We'll move on to the next slide, where we will discuss in further detail profiling. So profiling is again a new concept that has been introduced under the 21 regulation, which essentially means that it is an act of processing information about a person based on known traits or tendencies, including observed characteristics. And data subjects shall have the right to object to any decisions based solely on automated processing, including profiling. To give you a few examples of profiling, it would include like analyzing or predicting certain aspects concerning an individual's performance at work, health or personal preferences, or economic situations. And the data subject has the right to object to profiling anytime. We'll move on to the next slide. Personal data breaches. So while the 2021 law specifically defines the term personal data breach, the provisions stand the same from the 2015 regulation, which is to say that the controller has to report personal data breach to the commissioner no later than 72 hours of becoming aware. The processors are required to notify the controller of any data breach without undue delay. And if the data breach results in high risk to the rights of the data subjects, then the controller must notify the data subjects without undue delay. Moving on to the next slide. I'll cover the fines regime. So this is the provision that has drastically changed from the 2015 regulation. As you can see on the slide in front of you, the maximum administrative fine that is available now under the 21 regulation is a fine of USD 28 million, which is a considerable increase from the penalty that was available under the 2015 regulation, which was only a sum of 25,000 USD. And I say only because, yeah, in comparison to USD 28 million, 25,000 USD seemed a much smaller amount. And under the new regulations, the administrative fines apply to both the controller and the processors. And apart from the administrative fine, the commissioner may also issue a penalty for non-payment of data protection fees. Data protection fees, like I mentioned, that we discussed at the start of my presentation. So where the controller has not paid the data protection fees or has forgotten to pay the renewal fees, then a fine of up to 150% of that fee can be applicable. Apart from the administrative fines, the data subjects retain their rights to claim compensation as is available under the GDPR or as was also available under the 2015 regulation. So this brings us to the end of our presentation. I will now let Andrew run you through as to what needs to be done or what entities in the ADGM need to do in order to comply with the regulations of 2021.
Yeah, sorry for the timing, but just quickly, so having taken you through the new regulation, essentially what does that all mean? So really what you need to look at if you're an existing establishment is what compliance gap analysis you need to do of where you are now against where you need to be. So, and part of that, some of the matters you need to look at is, do you undertake high risk processing activities as described by the law, and does that result in need for having a data protection officer? You're going to have to maintain a record of processing activities. Need to look at updating your privacy notices to reflect the new data subject rights. Need to look at what your consent processes are if you have stuff particularly online, whether you've got that clear and unbundled consent mechanisms. Broadly as an organisation, is whether you have the appropriate technical and organisational measures. I mentioned in part that I discussed is if you're processing special categories of personal data regarding employees, you need to have an appropriate policy document for that. If you're using data processors, people to process on your behalf, you need to have a data processing agreement with them. And then if you're transferring data outside of the ADGM, you need to be clear of what your grounds are and whether you need to have any sort of adequate safeguards put in place for that. That's sort of a high level review of what's needed. Now, I appreciate it's after 3, but if we could just quickly look at some questions. One, was whether there's any indication of what the fees are. I'm not aware of that. Krishna, currently the fees are US 300 for registration and 100 for renewal, but I'm not clear of what the update on that. Krishna, have we had any indication in that regard?
Yes, so for the transition period that would run for the next 12 months for the existing establishments, the existing fee of like the 300 USD and the 100 USD would apply. And post that, we understand that the Office of ADGM Data Protection are in the midst of updating the guidance and the FAQs, and we should be they should be publishing those soon on their website. So that should cover the fees element as well.
And then another question is how consistent are the new data protection provisions with the GDPR? And can we get comfort that compliance with the new laws also provide a say level of comfort in provisions of the GDPR and what the salient differences are? I mean, the whole point of both the ADGM regulations and the ones introduced by the DIFC is to be updated to be consistent with the GDPR. And so adherence to the laws here reflects the standards of the GDPR. However, the GDPR is an EU law for people in Europe. There are some aspects of that. If you targeting or monitoring people in Europe, you need to have a look at what you're doing there, but much of the practice under these laws would have you in compliance there. The other question is, has there been any indication whether there will be an adequacy decision from the EU perspective for ADGM or DIFC? Again, not that I'm aware of them. The laws are new, but at the same time, the part of this process is clearly to be consistent with the GDPR and reflect the standards of the GDPR. So that's more watch the space. The question as to whether one of the legitimate basis for, legitimate interests as the lawful basis for processing is include advertising. there's an area of grayness, but in terms of the certain guidance, particularly from in the UK regarding a legitimate interest, is that direct marketing is a legitimate interest, but again, you have to be careful where that is on a continuum. If I'm an existing customer, would it be unreasonable to expect that I would want to have updates of new offers and things like that? So that's probably legitimate, but I certainly wouldn't be expecting you to be sharing my data with your partners for them to be bombarding me with that advertising. The one thing to be careful with advertising generally that I'll just comment on is if you're doing any kind of SMS campaigns, the TRA has recently updated its regulation regarding SMS campaigns, saying that there needs to be specific consent in that regard. Now, even though there's the ADGM and it has its own laws, the SMS messages will be carried over networks outside the ADGM. So that's just one thing to there. So regarding consent rights and as to whether it's included in general terms and conditions of a document or a policy, this is one thing that we'll have to, that's one of the things that does need to be assessed, because previously, and as a lawyer I've probably been guilty of this, as the consents probably would have been more bundled. Now I also have to note that one of the legitimate grounds for processing is performance of a contract. So if the performance of the contract or the terms of conditions, the agreement cover your use of the data, then that's agreement, and that so consent, if it's a specific type of consent, and the most common one of that is the sharing of the data with third parties, particularly for marketing purposes and things like that. You are needing to have to look at getting specific standalone consents for those kind of things. So you do need to have a look at what you're doing. I think that's probably all for the moment, and appreciate everyone taking the time. I hope that's given you some insight and help. If there's anything else, feel free to reach out to myself or Krishna if we haven't covered a question for you here. And look, appreciate you joining in. I thank Krishna for the presentation that, and also Joe and I from our team for running this, which this wouldn't happen without. And I'll let you get on with the rest of your day.
And just to add, yes, we will be sharing the copy of the slides, so they'll be sent to you after the webinar gets over. You'll receive them.
Thank you.
Thanks, everyone.
Bye.